Good evening. Good evening, everyone. I welcome you to the University of Tulsa College of Law and our annual John W. Hager Distinguished Professor Lecture. For those of you who I've not met yet, I'm Lynn Ensroth. I'm Dean of the College of Law, and it is really a pleasure for us to host Professor Orin Kerr, the Fred C. Stevenson Research Professor at George Washington University, who's here this evening to present a lecture on the important and timely issues surrounding the Fourth Amendment and its scope in our digital age. In a moment, I'm going to invite my friend and colleague, Professor Sam Halaby, to introduce Professor Kerr. But first, I want to just take a moment to tell you a little bit about the history of the Hager Lecture and the man it honors. The John W. Hager Lecture Series honors the memory of Professor John Hager. Professor Hager was one of those professors who is truly beloved by his students. And one of my former colleagues, Professor John Hicks, described Professor Hager as elegant. Students referred to him as the king of torts, and you'll find his portrait hanging out in the hallway of the law school, a gift from our alumni. And the portrait reflects, I think, that we have a gift from his students, I think reflects the mutual respect and deep affection and admiration that the students held for their professor. Now, Professor Hager exemplified the great classroom professor. And for first-year students, and I think there's some of them out here in the audience tonight, there is no class as beloved or feared as the study of torts. Professor Hager was surely a giant in the field of tort law, but Professor Hager didn't simply teach torts and the nuts and bolts of that area of law. He taught justice, that sometimes elusive goal of the legal system. And I think it is very fitting that when we talk about justice, that we think about the U.S. Constitution, and in particular the Fourth Amendment, and how it intersects with the law and individuals and their relationship with our government. Tonight, introducing our speaker is Professor Sam Halaby. Like Professor Hager, Sam is beloved by his students. And like all great professors, Sam's work with his students extends far beyond the classroom. Sam mentors, guides, and provides support for our students, perhaps most notably working with students who are seeking federal judicial clerkship and helping them achieve that important goal. Please join me in welcoming Professor Sam Halaby.
Thank you, Dean Ensroth, for that very generous introduction. Seeing as many of the faces of my students as I do in this crowd, I wonder if it's true. But I certainly appreciate it being communicated to the audience. You know, Dean Ensroth did such a terrific job of introducing the topic. There isn't a whole lot more I want to add, other than I would just sort of emphasize, as Professor Kerr has in his writing, when you really think about the number of electronic devices that you own and the amount of your life that you now conduct in cyberspace, in this kind of digital alternative universe, it just requires us to really think about how a document sort of penned over 200 years ago can still be relevant, under what circumstances and what we need to do as attorneys, as judges, and certainly as scholars to think about how that document needs to adapt. And perhaps nobody has done more than Professor Kerr at really contemplating those larger questions. His credentials will make it clear why that is so. He's a former trial attorney in the Computer Crime and Intellectual Property section of the Department of Justice. He was a special assistant U.S. attorney in the Eastern District of Virginia. He clerked for Judge Leonard Garth of the U.S. Court of Appeals for the Third Circuit, as well as Justice Anthony Kennedy on the United States Supreme Court. He has argued cases in front of the Supreme Court and 3 federal circuits. He's testified 6 times before congressional committees. In 2013, Chief Justice Roberts appointed Professor Kerr to serve on the Advisory Committee for the Federal Rules of Criminal Procedure. and appointed Professor Kerr again in 2015 to serve on the Judicial Conference Committee to review the Criminal Justice Act. He has undergraduate and master's degrees in mechanical engineering from Princeton and Stanford, and a JD from Harvard. And of course, he isn't somebody who just keeps his thoughts in the books or on the larger constitutional questions he studies. In 2009, he was also voted by the GW class as their best teacher. And so it is therefore a tremendous honor to welcome Professor Orin Kerr to address us this evening.
Well, thank you for that very generous introduction. It's a great honor to be here to give this named Hager lecture. I was delighted by the opportunity to be here, and I'm really honored with your presence. A great turnout of folks. So I want to talk about the digital Fourth Amendment. Here's the basic idea. The Fourth Amendment is the prohibition on unreasonable government searches and seizures. It regulates what the police do, essentially, when they collect evidence in criminal cases. It regulates when they can stop someone, when they can arrest somebody, when they can break into a house, when they can rifle through somebody's car, when they can open someone's mail, when they can watch somebody in the street. And the Supreme Court has, over the course of 100 or so years, really in the last 100 or so years, created a large body of law that says what those rules are. Pretty finely grained, detailed guidance that the police have to follow that says when they're allowed to do these different things. What's striking about this body of Supreme Court law is that most of it is dealing with physical world type facts, the kind of facts you'd expect in a pre-computer world where evidence is primarily physical evidence or eyewitness testimony. Think about this from the perspective of the government. You're a prosecutor, you need to prove your case beyond a reasonable doubt. You need to prove the elements of the crime. Those of you that are first-year law students know you learn your elements of the crime. And if you're a prosecutor, you have to lay that out before a jury and prove your case, all the elements beyond a reasonable doubt. Well, how do you do that? You do that primarily through eyewitness testimony. Someone saw the crime occur, can testify, take the stand and say, this is what I observed in the physical world. I saw him walk into the bank. I saw him steal the money. And also provide physical evidence of what happened. You have someone testify to the jury and say, here are the drugs that I uncovered in the suspect's kitchen underneath the sink. Here it is, show it to the jury goes, ooh, ah. And then everyone says, yeah, the elements of this crime have been proved beyond a reasonable doubt. And so the Supreme Court rules are naturally attuned to the kinds of facts that you'd encounter for the kinds of crimes that the government has traditionally enforced. So you can think about a crime of, it's a drug case, they're going to need the drugs, typically. That's the physical evidence of the drugs, and eyewitness testimony about the relationship between the defendant and the drugs. If it's a homicide case, they're going to need to prove, if there's eyewitness testimony, that's great. Maybe it's forensic evidence or something that shows this is the person that committed the crime. Someone was killed, and this is the person that did it. And that's typically going to be physical evidence and eyewitness testimony. Now enter digital evidence, and this is where the real challenges, I think, come from. We've entered a world where more and more often we spend our days using computers. And computers are remarkably good at generating records of what we do and keeping those records of what we do. So probably a lot of you have something like this in your pocket, or you're carrying something like this, and you might think of this as a phone, which is a quaint notion. This is a very powerful computer that happens to have an app, which is a telephone capability. It's really a computer. It stores an incredible amount of information, and you know the phrase that Apple introduced when they started these things, there's an app for that. That is, there's lots and lots of different programs you can load onto your phone, and every time you think there's an app for that, think there's evidence from that app for that. If you're a prosecutor, you want to go where the information is, and what better source of information than some means that keeps records of what people do and stores those records of what people do. This is potentially a gold mine of information for the government. And the question is, what are the rules the government has to follow when accessing that information? What are the limits placed on accessing that information? And it's a tricky question because a lot of the traditional understandings we have of the role of the Fourth Amendment and what the government can and can't do are uncertain or maybe are different in an online context than they are in the physical world context. And my broad perspective is that these differences call for a new set of Fourth Amendment rules, clearly related to traditional Fourth Amendment law, but in many ways applying the broad principles of the Fourth Amendment to the new facts of digital evidence to try to recreate the function of the traditional constitutional rules for this new factual environment. That's the basic idea. So I think, looking ahead 20, 30 years, we're going to routinely think, okay, what are the rules for searching a phone, or whatever we call them by then, or what are the rules, maybe by then it'll be, what are the rules of searching virtual reality? Who knows what it'll actually be. But the answers will come from computer-specific decisions, where the Supreme Court says, here's this traditional set of rules, and here's the computer answer to those set of rules. Now, some of you might be thinking, well, wait a minute here, Kerr. You're talking about a constitutional prohibition, the Fourth Amendment, that's been around for over 200 years. Why would we embark on this new task of creating computer-specific rules? What's wrong with the old rules that have done pretty well in the physical world? And I think what I'm proposing is actually not that different from what we've seen before, and an example I want to point to is the role of the automobile, the cars, in Fourth Amendment law. Those of you that have studied Fourth Amendment law know that a large chunk of Supreme Court cases and lower court cases applying the Fourth Amendment happen to involve cars. And when there's a car case, the courts go, whoa, this is a car case, and they apply the car precedents. They treat cars differently. Why? Why do they do that? And the reason the Supreme Court has done that is that the facts of the use of cars in the commission of crime end up being different than the facts of the commission of crime in other contexts. And the Supreme Court has had to adjust the rules to recognize the realities of how crimes are committed using cars. And perhaps the leading example of this is the first Supreme Court case involving searches of cars, a case called Kerr versus United States from 1925, in which the Supreme Court introduces what gets known as the automobile exception. And the automobile exception says that when there's probable cause to believe there's evidence inside a car, the police can search the car without a warrant. They need probable cause, which is the same cause needed to search a home, but they don't need a warrant. And it's presented, the Kerr case is written by Chief Justice Taft in this very originalist way. It draws analogies to the common law rules for searching boats, for example, and says, well, cars are like boats. Well, I don't think that's what was actually going on in terms of explaining the court's decision. And interestingly, Chief Justice Taft wrote a series of letters, including some to his brother, talking about the problem posed to crime by the automobile. And Taft, in these private letters, describes the automobile as the greatest engine of criminal activity ever devised. And the reason is, imagine it's 1925, and you're the Chief Justice of the Supreme Court. You're trying to figure out, what do we do with all these prohibition agents? We have prohibition that's just been passed a few years earlier, and we expect the prohibition to find the alcohol that's being distributed illegally. And how do we do that? Well, how is the alcohol being illegally distributed? Well, with cars. And what did cars enable? Cars, first of all, they all look the same from the outside. They have trunks. You could open up the trunk, and you could put alcohol in the trunk and drive at what the courts, in great opinions from the 1920s, talk about this, at rates of speed that are only comparable to the railroad. I mean, this is the notion of, we've created this monster, this technological monster, and the problem was Fourth Amendment law as it existed before the automobile exception only recognized two rules. Either something was not covered by the Fourth Amendment, or a warrant was needed to search it. Well, this sort of puzzled the courts in the early 1920s. How do you impose a warrant requirement on the search of a car? Because what's the officer going to do? The officer, pulls over the car and says, okay, I think there's moonshine in the trunk of this car. How's the officer going to get a search warrant? Is the officer going to leave? Say, please stay here for the next 8 hours while I go find a magistrate judge, and it's the weekend, and it's not like there's cell phones or anything. I'll hopefully find someone. And so what the courts did is they said, listen, on the spot, the officer can make the decision if there's probable cause, the search of the car is allowed. And what that did, I think that basically adjusts the traditional Fourth Amendment principle to recognize the facts of automobiles, that automobiles are quickly movable, and you can't have a warrant requirement, because if you have a warrant requirement, it's going to be basically defeat any officer investigation, because they're not going to be able to conduct the search practically. And so we see in Fourth Amendment law today lots and lots of Fourth Amendment rules on cars. Rules on when cars can be stopped, when the officer can get people in the car, out of the car, when they can search the car, all sorts of Fourth Amendment cases. And I think the computer will be to the 21st century Fourth Amendment what the automobile was to the 20th century First Amendment. So we're going to have the run of cases on computer-specific facts, where the court says, how do we apply these Fourth Amendment principles to the new facts of computers? And interestingly, I think we've actually seen the first of these cases already. The case of Riley versus California from 2014. So Riley dealt with a Fourth Amendment doctrine called the search incident to arrest doctrine. And the idea is that when officers make an arrest, they have a power to search people they have arrested. And this is a common law authority. It goes back hundreds of years. And it's been justified generally on the grounds, well, first of all, the person might try to destroy the evidence that's located on them. And so the officer can search so to avoid the destruction of the evidence. And then also the person might be hiding a weapon. And so you want to allow the officer to conduct the search to make sure there's no gun or knife or something that might pose a threat to the officer. And in a 1973 decision, United States versus Robinson, the Supreme Court said there's a bright line rule. Here's the bright line rule. Whenever someone is arrested, the officer can search the person and all property on the person. Does no case-by-case discussion of whether it's reasonable in that context to conduct a search. Arrest equals complete search of the person. That was the 1973 decision. And it arose in sort of classic physical world facts. Suspect is driving, pulled over, arrested for driving without a license, and then the officer starts doing a search incident to arrest, finds a crumpled cigarette package in the officer's pocket, in the suspect's pocket, opens up the crumpled cigarette package and finds heroin. And suddenly the case that was about driving without a license becomes a drug case. Robinson's lawyers say, well, that was not a reasonable search incident to arrest. It obviously had nothing to do with the evidence required to prove driving without a license. It's not like the absence of a license was going to be found inside the crumpled cigarette package. And it's really unlikely that inside the crumpled cigarette package there would be a gun or maybe a knife. There was some discussion, maybe it could be a razor blade. But it was clear that the officer was not searching for that reason. And the Supreme Court just says, listen, bright line rule, we're not going to look into each case. The officers need to know what the rule is that they can follow. So that's the Robinson rule in 1973. And then people start carrying these. They start carrying cell phones. And it's kind of an amazing thing to think about how quickly cell phones have become just a standard part of life, and how quickly cell phones themselves have changed. So maybe cell phones really start being introduced maybe late 1990s. People start using them. In the 80s, yes, but it was basically drug dealers and doctors that was kind of using them. But in the 1990s, it becomes a very common thing to carry, late 1990s, to carry a cell phone, early 2000s. And then you get the introduction of the smartphone. And it goes from just a phone that maybe stored a little bit of information to really a pretty sophisticated computer. And the introduction of the smartphone is kind of an amazing thing as you watch this change. Year by year, the percentage of people who are carrying a smartphone with them just spikes until it reaches something like, I think now it's something like 75 or 80% of all adults in the United States own a smartphone. It becomes hard in buying a phone not to find a smartphone. I have friends that say, I really just want a flip phone, and it's hard to find. And so that's just the world we're in, and that means there's an amazing amount of evidence that's stored on people's phones. And think of how the Robinson rule connects to the reality of smartphones. Bright line rule, can search everything. Well, from the government's perspective, that's kind of awesome. right? Whenever someone is arrested, the Supreme Court has said, bright line rule, that stuff can always be searched without a warrant, no cause required, no suspicion required, and a complete search is allowed, and that means, you know, whatever, 100+ gigabytes of information that could be stored on the device, text messages, photographs, you know, contact lists, phone logs, you name it, lots and lots of information stored about people on their phones. And in the Supreme Court's decision in Riley versus California, the Supreme Court unanimously holds that the traditional physical world rule for searches incident to arrest does not apply to cell phones, and by implication, to all digital storage devices. The Supreme Court says, this is totally different from what we were worried about in Robinson. Phones store so much information, and they store so much personal information. The amount of information stored on a modern smartphone is the equivalent of what traditionally would be in an entire home. And we can't allow a search incident to arrest of essentially an entire home without some judicial scrutiny. What the court is doing, I think, is basically saying the facts have changed. The implication of the Robinson rule was modest because people didn't carry that much evidence on them. And maybe you might have a booklet or something that had, you know, contact numbers, but it was not going to be 100,000 pages or millions of pages. It might be 5 pages. And so that was allowed in the physical world, but a different rule is required for the electronic world. And the government had argued in its brief in the Riley case that the facts of modern smartphones were really not that different, and therefore the Robinson rule should be retained. And the Chief Justice, in his opinion, says that's like saying a trip on horseback is materially indistinguishable from a trip to the moon. Both are ways of getting from A to B, but little else justifies lumping them together. And so we have in Riley the introduction of a computer-specific rule. So the sort of the Cliff Notes version, or what students enter into their outline, is incident to arrest, physical property, search without a warrant, digital property requires a warrant in incident to arrest. So basically a physical rule and a digital rule. And I think this idea from Riley is something that we're going to see again and again in lots of different contexts as the courts create this digital Fourth Amendment, just a set of rules specifically for digital evidence. So, for law professors, that's pretty cool. That's pretty exciting. It means, new rules is always good because it means there's something to talk about. Developments. When you write about public law, you certainly want there to be a lot of developments, because otherwise, what are you going to say, right? You have to new based on the old materials. Much better for there to be new developments that you can comment on and talk about. But what this means, if we're going to have a digital Fourth Amendment, we have to figure out what are the rules that characterize this digital Fourth Amendment. What are searches? What are seizures? When are searches and seizures reasonable? What do warrants look like? How does this apply online? In the last few years, we've started to see a lot of responses to the widespread introduction and use of encryption. People can hide their information from the government, even if the government has a traditional probable cause warrant, and that forces the government to use different techniques to try to get around the use of encryption. Courts have to grapple with the legality of that. So what we're going to see is just a wide range of different contexts in which courts adopt new rules that are really computer-specific rules coming down the pike. So what might some of those computer-specific rules be? Well, there's a lot of different aspects of this, and I can't cover all of them. If I ever actually get around to finishing this book, you'll be able to read a book that talks about all of them. But at least right now, I can only talk about a couple examples that I think sort of highlight the problems. And these are hard judicial problems of what the rules should be when you recognize in this Riley-like way that you need new constitutional rules. And so I want to talk about search warrants as my leading example. So search warrants are just court orders that a judge signs and says you can go to a particular place and seize particular property because I found probable cause that there's evidence of crime in that place, and you can seize that evidence. That's the basic idea. And in the physical world, search warrants operate kind of in the way that you see on TV. The officers break into the house, they look around, they rifle through stuff, they find the responsive evidence, and then they leave. It's a brutal process. It's not sort of a like knock, 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 hello, may we search. Typically it is much more invasive than that. But you can understand kind of what it means. A warrant says, here's the things we can take. Officers go into the place to be searched and take those things. Well, introduce digital evidence and things get a lot more complicated. So imagine you're a police officer and you're searching a house for evidence of a fraud crime. And the fraud crime, let's say, you believe to have at least taken place last year, maybe it was going on for a couple of years, and you know it's a fraud scheme, and you want to get the evidence of the fraud scheme. So you're mostly looking for financial records and that sort of thing. Well, you go into the house, let's say the suspect's home is the place to be searched, and your warrant says you can seize records of fraud crime. Okay. Show me the fraud crime. Well, one of the first things you'll probably notice, a bunch of computers, right? So pretty much in everyone's house, maybe there's a desktop computer, some external hard drives, some cell phones, some thumb drives. Think about in your house or apartment or dorm room, how many electronic storage devices you have. And don't only include the ones you currently use. Remember, there's all the old computers that you stuck in the closet? Those are all there too. And the government doesn't know that those ones haven't been used or might have evidence of the crime either. So if you're the officer, what do you do when you execute that search and you find 3 laptops, 5 external hard drives, and a bunch of thumb drives, CD-ROMs? The problem is twofold. One is that you can't tell from the outside what's on the inside, right? You don't know the information that's stored in there. And the second is that there's an incredible amount of information on these electronic storage devices. Just to give you an idea of this, a typical flash drive that you might have like on a keychain or something, those are usually maybe 32 gigabytes, something like that. You can get ones that are still 2.4 gigabytes and up to maybe 512 gigabytes these days. Each gigabyte is roughly 65,000 pages of Microsoft Word documents. So if you're talking about a thumb drive that is 32 gigabytes or double that, you're quickly going into the millions of pages, possibly, of information. And that's one thumb drive, right? An external hard drive might be 5 terabytes. It's something you can buy for like $100 on Amazon.com. That's the equivalent of 300 million pages of information that could be held on that storage device. So you're the police officer, and you go into the house, and there's could be 1 billion pages worth of data that you're supposed to go through. Well, how do you do that? Well, what courts have said is that justifies a 2-step search process. Just as a practical matter, the only way you can carry out that search is by doing it in 2 different stages. Officers have to be allowed to take the digital storage devices and bring them back to the forensic lab, and then some forensic analyst is going to make copies of those digital storage devices and then search the copies using forensic software that has been designed for this purpose, designed for law enforcement. And how are you going to search through that back at the lab? Well, it's going to be pretty invasive because the information could be anywhere. Think about the difficulty. You don't know, if you're the officer, where in the billion pages worth the information might be located. A lot of times there will be ideas of where it might be. Let's say you're looking for emails, you think, well, it's probably in the email account, or you look for certain characteristics of email, and it's more likely than not, maybe the odds are decent, that's the first place you'd look. But what if you look through that and it's not there? You don't know if it might be somewhere else. It's kind of like, to draw an analogy, you're looking for records of fraud crime, and you have a warrant to break into someone's house to look for those records, and the first thing you do, maybe you see a filing cabinet, you pull up the filing cabinet, and it says fraud crime, or it says tax records involving that special, whatever it is, something that says, aha, this is probably the place where it is. And you look through it, and you don't find what you're looking for. Well, you're not going to say, darn, we're done. It's a big filing cabinet. You look through one folder, you're not going to be like, well, we looked through the one that said tax records, and we didn't see it. So we're not going to look at the one that says, family vacation, because guess what? People can put the folders of the fraud crime in the family vacation folder. There always is a chance the information could be somewhere else. And so the Fourth Amendment particularity requirement says the limit is on the place to be searched, the house. It can't be multiple houses that are searched, or a city block searched under a search warrant. It has to be a house. And then the limit is on the evidence that is going to be seized. Well, computers effectively mean that the amount of information that could be in the place to be searched is exponentially larger than it used to be. And so courts have allowed this two-step procedure. And the difficulty is that at the first step, as a practical matter, officers need to do this, sort of take everything, and then they can look through everything. And because they need to look through everything in order to make sure they're finding what's responsive to the warrant, that often means that information that's not responsive to the warrant comes into view in the course of looking through the files. A lot of the cases where this comes up are cases involving child pornography, where officers will be conducting a search for one kind of evidence, and for example, the forensic software might allow them to view all images that are available. They press the button, view all images, and go, okay, suddenly becomes a child pornography case. And the rule that the Supreme Court has had in the traditional physical context is something called the Plainview Exception. And the basic idea is that if it's evidence of crime and if there's probable cause to believe that other material is evidence of crime, the officers can take that too. The physical example might be officers are looking for records of fraud crime and they see marijuana. The officers don't have to say, like, I didn't see the marijuana, I didn't see it. They can see it and they can take it. And there have been arguments made in Supreme Court cases that has to be a narrow exception because doesn't it give the police incentives where they think there's other stuff to look, to actually sort of secretly look for the other evidence. And the Supreme Court said that's just not very likely because the particularity requirement is strong. The particularity requirement says you can only go to that particular place, and once the officers find what they're looking for, they have to leave anyway, so we're not too worried about these sort of searches for other reasons. Well, in the computer context, I think the dynamic changes considerably because anytime the officers have probable cause to believe there's evidence of any in the place to be searched, suddenly they can see basically a person's entire digital life and come across other records as long as it's immediately apparent that the other records involve some sort of a crime. So probably that wouldn't be records of a different fraud where you need to sort of assemble it together to know the fraud was being committed, but other offenses that are more obvious and you know, the child pornography cases are probably the most ones that, or at least most common in the cases. You know, the concern is that at stage one, the officers have to take all the computers, but then at stage two, they're effectively being allowed to see everything on all of the computers, and then at stage three, if they can use all of the evidence that they see that they come across, what does that do to the Fourth Amendment? The whole point of the Fourth Amendment, what animated its passage, was a concern with what were called general warrants. General warrants, the idea is that it doesn't say what the officers are specifically looking for, and it doesn't say specifically where they can search. It's kind of, we want to find everything about this person and look through it all and then figure out what we think is the evidence of crime. And the concern is that digital evidence warrants effectively, because of the facts, become general warrants under the traditional set of rules governing searches, especially the Plainview Exception. So what's the answer to this? You know, what are the rules that the courts should recognize? One is to stick with the status quo, or at least to allow, you know, full seizures of everything at that initial physical search stage, and then forensic search through everything at the second stage, and seizure of everything that ends up being even beyond the scope of the warrant if it looks to be evidence of another crime. But I think that just doesn't limit enough. It basically allows anytime the government has probable cause to get the warrant. Basically, it exposes a person's entire digital life to scrutiny and to potential use in court. So what are the alternatives? Well, one alternative would be limiting the physical search stage. A rule that when the officers go and they're executing the warrant for digital evidence, they can't just take everything. And the problem is, I think, just practically speaking, the officers can't find, they don't know where the evidence is going to be. And so there are cases, there are a lot of examples to talk about, but cases in which the officers, you know, go to the home and they see 3 hard drives and 3 external hard drives and 5 laptops and 10 thumb drives, and they search through all of them, and all the evidence ends up being on 1 thumb drive. Well, how do you know which is the the thumb drive that has the evidence. If there was some magical way you could do that, it'd be great. And we could say, the Fourth Amendment just says only take that thumb drive, but you can't know. And so I think the physical search stage is not the right place to impose that restriction. Another possibility would be to limit how the police can search at the electronic search stage. That is, you could say, for example, as some courts have tried to do, they can only look in certain parts of the hard drive. They can only, if it's messages they're looking for, they can only look in the email account. If it's images, you can only look in the image. And I don't think that works, because it's just, once a court actually announces that kind of limit, imagine the Supreme Court says, in messaging cases, you can only look through email. Well, that's cool. If you're trying to commit a crime, you just make sure you've hidden all your records in ways that can't be searched by whatever methodology the Supreme Court has said is required. So I don't think that works either. I think there's really no substitute for allowing the government, if they have probable cause justifying the search and seizure of these records, to look through everything. I think the answer has to be in some kind of use restriction on the information that is revealed. And so what I've proposed is to interpret the Fourth Amendment to say that the seizure of non-responsive information, that is the information outside of the scope of the warrant, is only constitutionally reasonable when that information is not used. So the information that is non-responsive can be seized initially at the physical search stage, but if the government comes across information that in a physical world setting they'd be allowed to use, they should not be allowed to use that in the digital setting. Essentially, the rule would be for the police, draft your warrant carefully, because you can't take advantage of the Plainview Exception anymore. Yeah, you can seize all the computers at the physical search stage, you can look through everything at the digital search stage, but you can only actually use that which is within the warrant itself. You can't sort of start using other stuff you find. So that would be, in some ways, a more flexible rule for law enforcement, in that they can overseize, right, because it's technologically necessary, and they can look through everything because it's technologically necessary to get to that which the warrant describes, but it's also more restrictive towards law enforcement because they can't use that which would be outside of the scope of the warrant. My hope is that that would offer a way of maintaining the traditional function of the Fourth Amendment in a new factual environment where there's just so much data that is stored, and it's so time-consuming for the government to find that which is actually responsive to the warrant. Now, there are exceptions. I think if the information outside of the scope of the warrant is itself a cause of exigent circumstances to conduct searches. The example I often get is, what happens if the information outside the scope of the warrant is about a terrorist attack that's going to happen later that day? Hard to imagine how that actually could happen, but let's imagine it happens. Or other crimes where you can imagine ongoing crimes that are occurring and the government learns about it through the forensic search. I think there could be an exception under exigent circumstances that would allow the government to act on the evidence that they found, on the theory that the reasonableness of that seizure is affected by the exigent circumstances revealed by the information the government sees. So they would be, in some cases, allowed to use the information, but at least in the ordinary case, would not be allowed to use the information. Is it a perfect answer? Absolutely not. I'm a strong believer that all interesting answers in law are the least bad answer to whatever the problem is. Because if there were a good answer, then we would have found it. We'd all go, yay, we have good answers, and we wouldn't have to worry about it. The interesting questions are all the ones where you lay out all the possible options and you say, gosh, these all stink. But here's the least bad, which is the positive, optimistic way of saying it's the best of the answers. So that's how I would approach digital evidence warrants. And I think given the time, I want to actually, instead of going through other examples, maybe I can weave them into my answers in Q&A, because I really want to get to your questions rather than just drone on. So I'd love to open it to your questions about the general approach, the example of warrants, or we can certainly talk about lots of other examples that are in the headlines or not. Thank you.
So first, let's go ahead and give Professor Kerr a thank you very much. I would agree to sort of keep this room. I don't know all of you. I believe that Robert was first, and then.
I had a question on how you envisioned, so if I understood this correctly, then the use restriction would be in terms of admissibility to bring other charges. But what about to spur other investigations? For example, if somebody emailed with a co-conspirator banker or something, would they then, like, that would put investigators on another sort of trail that they could follow? Would they be allowed to do that? Because it seems like you would find yourself, like, you could accidentally give somebody a free pass if that were completely cordoned off. Basically, you would never be able to prosecute that other person or follow that trail unless you came up with some sort of independent, probable cause to follow it, and I'm not sure how you would do that without, chasing your tail a little bit.
Yeah, great question. So I think the use restriction would have to go beyond use in court. It would, first of all, have to include, couldn't be used as cause to justify, for example, a warrant. So what courts have said is, we will only allow that information to be used to justify another warrant. But if that's the case, it just becomes a paperwork requirement because it's not necessarily probable cause itself. So I would say it can't be used as evidence to gather cause. It can't be used in court. Can't be publicly revealed. I think the public revealing of information would be a transformative use that makes the reasonableness of that seizure unreasonable. The question of sort of how do you draw that line between sort of opening an investigation? So the hard case would be officer searches the computer and realizes that the suspect did not commit this crime, is actually completely innocent of this crime, but did commit another crime that's worse, really bad. And so do you let the government watch that person? Or what if that officer says, I've seen things on that hard drive that make me think I want to go downtown at around 11 p.m. on that street corner just to see what's going on. I just happen to be driving by. And is that, does that become a Fourth Amendment violation as an unconstitutional use? I find it tricky, and it's a tricky and important question as to exactly where that line should be. I'm mostly focused on the ex-ante incentives, sort of what, we wouldn't want it to be that the use restriction is so ineffectual that it's really just a paperwork requirement. Would we want, is it enforceable to have a rule where there's an absolute ban where the officer can't drive by that, that place and time? I'm not sure. I think the trickiest question is sort of, is the sort of giving the officer the idea to do something that is not a search or seizure, and that also does not reveal the information. I think that one I genuinely struggle with. I don't know if you have an answer. I'd love to hear it. Credit in my book, but yeah, I think that one's a really tricky question.
Where do you see the Fourth Amendment going with the cloud, where the data is stored on a drive owned by a completely unrelated third party?
Yeah, this is a great question. This was my second topic that I was going to talk about if we had time. So I think the presumptive answer should be that courts should draw a distinction between the contents of communications and non-content information held by third-party providers, and that contents of communication should be presumptively protected by the Fourth Amendment, and non-content information should not be protected under the Fourth Amendment, which so far is actually what a bunch of courts have kind of suggested the rule should be. And my thinking behind that is I think you can understand the internet as a way of doing remotely what we used to do in person. And you can understand basically all communications networks as ways of allowing us to let our fingers do the walking, as the old Yellow Pages ads used to say. And then when you think about networks that way, you can draw equivalence between information that in the physical world would be protected and information that would not be protected. And when you draw those equivalents, the rule that you end up with is that content should be protected and non-content information not protected in the following sense. So imagine a physical world rule. I want to go to a colleague to visit because I'm planning a crime. We're going to be conspirators in some crime, and I want to go visit him across town to meet. I would leave my house and I would walk across town, and if the police were tailing me, there are certain things they could find out without committing a search or seizure, and that would really be kind of when I left, where I was going, and where I went, the building I walked into. And that's kind of the metadata of that exchange. They wouldn't know the actual conversation, but they would know the metadata of when the communication was started, sort of what led to that. And I think you can draw the equivalence then that non-content information of say, emails are kind of the metadata, how the connection records that are the equivalent of what in the physical world would be unprotected, whereas the actual contents of the communication are the equivalent of what would happen in that private space, and that the presumptive rule should be to maintain an equivalence between physical world and digital world rules, or amounts of protection, that the contents are protected and the non-content is not protected. That should be the presumptive rule. There are a lot of proposals to do things a little bit differently. Some scholars have argued that the distinction between content and non-content is actually sort of hard to draw. It can be. Their courts have been struggling in some particular cases involving what exactly that line is. But I think presumptively that's the answer that effectively maintains the amount of protection from the sort of transition from a physical world where we actually leave our houses and go do things to the world we live in, the digital world, where you just stay in your apartment or dorm room or house all day and just do everything remotely by surfing the internet. So that's I think the presumptive answer, and there's pressure on both sides to change that a little bit, but I think that's the starting point.
Professor Lancaster. So I realize that there are differences between the criminal and civil context, but some of the issues here on the criminal side remind me of some of the issues that go on in the civil side with respect to e-discovery, where you have these large, corporate databases full of information, and you're not just going to let opposing counsel come in and look at absolutely everything that you've got, right? And so there are a variety of methods that are used. Sometimes you'll haggle with opposing counsel about the kinds of search terms that you'll use to sift through the data, and other types of solutions, right? Sometimes they want direct access and somebody's looking over their shoulder as they search through the database. And you can fight, ask the court to referee these fights as well, and they have to limit the scope of their requests and so on.
Yep.
And if you are searching in a properly tailored search for one kind of data, and you have an email that's relevant to the subject of the litigation, and it also has other stuff that's in it that is damaging, that's just sort of how it goes, right? But it's incidental to the actual search. And I wonder if if there isn't a similar method that could be employed on the criminal side, where it wouldn't preclude evidence that isn't related to the specific crime that's being searched for, but anything that was gathered up sort of incidental to that narrow kind of search would be fair game.
So the question of drawing the civil criminal similarities, or trying to use some of the rules that are evolving in the e-discovery context is a tricky one, because the understanding is in the criminal context we're dealing with something that's pretty different. So we're dealing with a government that has a search warrant. They've shown probable cause to believe a crime has been committed. It's presumably a step towards an indictment, criminal prosecution in jail. We're talking about sort of a different set of stakes than civil discovery between two big companies, something like that. And so the efforts that at least have happened so far to try to take advantage of e-discovery answers in the criminal context, a couple magistrate judges have tried to draw that analogy, and the district judges have reviewed them and said, no, these are search warrants. These are, in the civil context, we don't allow the one side to take a battering ram and knock down the door and rifle through everything and rifle through the bathroom and throw all the stuff around and say, oh, sorry, we broke down the door, here's $100. It's a very different procedure because the stakes are different, and we just have a different set of instincts as to that. And so I think what's tricky to my mind is that in the criminal context, there are just different incentives. There's a different need. We have repeat players. The police are not, folks that just happen to be involved in litigation at that particular time. Like, their job is to collect evidence. And so all the concerns about state power and abuses of state power that are so sort of traditionally fundamental to Fourth Amendment law, I think play a different role than would happen in the e-discovery context. So there's some similarities, and some of the facts certainly are similar, but I'm wary of relying too much on the civil discovery rules.
Professor Arnold?
By your own admission, electronic items are very different than a physical search. Physical search is actually a small thing compared to what I can have on here. And we start with the premise that a number of these constitutional rules take into account that the rule justifies, in some cases, limits that will involve people going free who are guilty, or evidence not being discovered that might point to a crime. And going back to Professor Lampkin's question, once you have in possession of law enforcement my, 12 Blackberries and all this type of stuff, it's hard to imagine that law enforcement isn't going to go through every bit of it. And therefore, I don't know why you couldn't do something like done in the civil context with predictive coding and machine-assisted discovery to narrow down what's being looked for, and then if you do, in fact, once you've done the predictive coding, pull out something that doesn't relate to it, then it's plain view. And maybe not even, maybe have someone other than law enforcement, once you've decided what you're looking for, do the looking.
Yeah, on the latter point, there have been occasional efforts to appoint special masters to review the computer forensic process. And typically what happens is, 5 or 6 years later, there's a there's a question as to what happened to the special master, because it just takes so long, and in a fast-moving criminal process, especially with statutes of limitations, the special master's procedure has not been seen as particularly effective. What makes it tricky too is searching when I've asked this question to sort of government computer forensics folks, here's what they've told me in response. Searching a computer in a criminal case, it all just depends on how much evidence you think you need. And the judgments you need to make as to where to search and how much evidence you need and how long the search takes just completely depend on the case and how many resources are required. Maybe a case is not seen as all that important and you just need to find a certain threshold of evidence. Maybe it's really important and the government has decided based on other information they just need to nail this guy because this person's really bad. And those sorts of judgments are hard to reduce to rules or to have some sort of oversight of what essentially is kind of a prosecutorial discretion or investigatory discretion, I guess. And that it's tricky to reduce that to a set of rules that could be managed. One thing some magistrate judges have tried to do is impose what I've called ex-ante search restrictions, rules in the warrant that say this is how the warrant is to be executed. They might say the first thing you need to do is look for keywords, and then the second thing you need to do is then you can look in the slack space or something like that. And the difficulty is it's awfully difficult, I think, for magistrate judges to know what would make sense in context. Some magistrate judges have said, you have to search this computer in a reasonable way. To which you ask, well, the Fourth Amendment has sort of already covered that ground. The question is, what is reasonable? And you got to figure that out once the investigation has actually occurred. So I'm skeptical of these search restrictions. And then the other problem is usually the restrictions will say, if you don't like this search, come back to me and I'll consider letting you do a different search. Well, how is the magistrate judge supposed to decide? I think you're now allowed to do a particular query. It's just something that's difficult for magistrate judges to figure out. So there are possible ways of doing it, but given the volume of these cases and the difficult judgment calls about how much resources go into different cases, I think it's difficult to have that kind of oversight. Not impossible, but I'm skeptical.
Yeah, that leads into my question, and that is, we're getting tools, algorithmic, analytical tools, and artificial intelligence tools that will be able to crunch, for example, temporal data, spatial data, and to crunch and integrate temporal data, spatial data, and informational data. Now, you mentioned the case of, finding out that there's an imminent terrorist attack. If society finds value in certain information, then it seems like the ability to make connections that would normally not be made because of sheer time, once you have the analytical ability to go through a billion pages and synthesize all this data out, gives you capabilities that you haven't had. I know you've thought about that. What might be applied to both control or limit or protect based on the technology that is now being deployed?
So just so I understand, the question is, are we dealing in the search warrant context? Should the government be allowed to use those techniques to try to draw lessons that they wouldn't otherwise draw? Is that this, or is this more
the tool
outside of the warrant context?
In forensics, you're going to go, for example, ICE did a case back in 2010 where they got a drug dealers from the Russian mafia, they got his laptop, they dumped the emails, and all of the deals that this guy was making in drugs were in his emails. So the guy came into court, pleaded not guilty. The prosecutor took out a pile of papers and dropped them on the table, and the guy asked his lawyer, "What's that?" The lawyer asked the prosecutor. He said, "Those are all the incriminating emails." So he changed it to a plea deal on the spot. Okay? It turns out that some of the emails were just fluff, but they had dumped everything. Okay? So it was, and this happens obviously in law enforcement. So the idea was, in that case, they just did a blind dump of everything, but they could have run it through basically an algorithmic filter to say, I want the emails that do X, Y, and Z, and it can look through a decade of, of 500,000 emails. I mean, if you want to be cynical, you go into the search and you say, okay, I want to limit not only the search, but I want the laptop limited to the search dates, and then I want the laptop wiped, and a hammer taken to my BlackBerries. But you're not going to get that in real life, in real terms. So how do we account for the ability to do the searches in a higher or more comprehensive way, and especially since you can limit the filters, but if society says, gee, if you find any evidence of terrorism, we want to know about that.
Yeah, so first of all, I'm skeptical about the ability of these techniques to do something different than what we're used to having seen, for the following reason. Even if there's sort of a proof of concept that a certain technique can be used to predict something, there's a huge gap between that and it can be used in a routine criminal case. So, the local police or even the FBI can actually do that to get anything useful. So there's the first step of, can this technique actually be used? And then the second thing is, if it's proven that that technique can be used, and if it's used regularly, then the bad guys are going to start thinking about, what are my ways around that? And so you get, I think, kind of a cat and mouse game that keeps the possibility of new government tools that really change this dynamic from coming to fruition, at least in an obvious way. So it may be that in 50 years or 100 years, computer forensics looks so different than it does today, that the rules that I'm proposing now end up being like, people say, hey, well, that was the 21st century rule, but in the 22nd century, we have a totally different rule. That's possible, but I think I'm skeptical that technology can act in this sort of one way, as a one solution to solving these problems. And to some extent, we're seeing this now. More and more, we're seeing the role of encryption. More and more data is encrypted, and so the sort of plans of the government's going to be able to solve these crimes really easily. Actually, it's kind of going in the other way in a lot of contexts. And so the cat and mouse game, I think, continues without an obvious winner so far.
All right. Well, then, Professor Allison, last word.
Well, This question raised to my mind the Tom Cruise movie Minority Report, where you get so good at artificial intelligence and predictive power that you pretty well can see the future.
Yeah, I mean that's at least the concern. I'm always wary of this. So I was back when I was at the Justice Department before I started teaching. I was working on a case, an investigation that included, there were criminal law investigations, there were national security investigators working on the same case. And at the time, this is the time before the Patriot Act, when there was a strict wall between the two, so we could only talk about certain topics, and we couldn't actually share the evidence we had. But at one point, somebody had asked, hey, I have an idea. Can we do the following thing that would allow us to solve the crime? And the agent said, only in the movies. In the real world, couldn't actually do those things, but in the movies, it was possible. So, I'm skeptical. Things in the movies may come to pass, but I'd want to actually see it beforehand, because there are always two sides here that are each trying to, the government's always trying to collect evidence, and the people committing crime are always trying to hide it, and so. And then the people, of course, have their ways of making sure that certain things don't come to pass by telling their elected representatives, we don't like this, and we're, that is actually something which is coming to pass more and more in the last few years with passage of statutes. There's one in California, the California Electronic Communications Privacy Act, which imposed the strongest set of privacy restrictions we've seen so far on the government collection of digital evidence, out of a strong set of civil libertarian ideas passed the legislature, and the governor signed it. So the legislature obviously plays a significant role here as well. All right. Thank you so much.